I was expecting them earlier, that's good.
Okay. Bonjour, moi je m'appelle Moussa Kamara. Je suis doctorant en droit à l'Université Laval. Et je remercie Professeure Fannie, qui est d'ailleurs ma directrice de thèse, pour son exposé, son brillant exposé. Et vous avez parlé tantôt de l'instrumentalisation de la Cour pénale internationale. Et cela m'amènerait à poser la question suivante. Est-ce que la Cour pénale internationale n'est pas une juridiction à deux poids, deux mesures? Et qu'est-ce qu'on constate? On constate que c'est une juridiction qui s'attaque plutôt, disons, aux responsables des pays qui défient l'Occident, je veux dire la France et les États-Unis. Donc, tout en évoquant le cas de Gbagbo et de Charles Taylor. Voilà. Et la deuxième question est la suivante. Est-ce que l'une des forces de la Cour pénale internationale ne réside pas dans son caractère répressif, contrairement aux autres juridictions régionales telles que la Cour européenne des droits de l'homme et la Cour africaine des droits de l'homme et des peuples? Je vous remercie.
Do you want to go ahead and answer?
Oh, no. I'm sorry. Mark was recognized before you. And if we have time, we come to you. Okay? Okay.
I'm Mark Nierenberg. I'm co-counsel with Philippe Larochelle in the Mungwarari case. And I can tell you that your students have been a great help to us. And I want to thank you for a very thought-provoking presentation. And it provoked a thought in me that I'm going to ask your opinion on. As you were describing how more and more it's going to international law is going to be settled in the jurisdiction of separate countries. I'm wondering, isn't there a risk here of countries developing parallel, different jurisprudence because they're not subject to each other, and shouldn't there be some sort of international court of appeal above them all?
Okay.
Maybe you can ask your question and she could deal with both. Okay.
Hello, my name is Arga Van Jarami from Jarami Law PC. And my question is this. When we recognize that the selectivity of the international justice system has caused, has jeopardized the legitimacy of that system, then how can you work within that system still? Essentially that is what the challenge is, because it's bringing into question its very legitimacy. So for those who recognize that, then how do you grapple with how do you reconcile that with working with the ideas and the points that you've raised in your presentation, which is we can't go back. So that's my question.
Thank you. I'll start with you. Maybe the selectivity in as maybe two angles. First is selectivity within a conflict, as we said, going against only one side of the conflict. That is easily you can solve this. You can solve this in a sense of denouncing this situation and trying to correct this. I think this is a fact that has happened in Rwanda. This is a fact that is not completely finished in the ICC. This is what we see now, indictments only against Gbagbo, and eventually his supporters. We'll see about Ouattara, but then, clearly against only the LRA. They haven't been arrested. So at the ICC, it's not a settled deal. We can, I'm not saying it's what we see happening, but it's not really what's going to happen. In Rwanda, it's already a little too late, and we can denounce it. Selectivity is within the same conflict or within countries and individuals. So nothing against George Bush, nothing against Stephen Harper, but everything against African leaders. This is the major challenge, as you said. How to work within it is also how to solve the bigger issue. That's what I'm saying. The biggest issue is that the U.S. is the superpower, and the U.S. has the veto in the Security Council. I hate this situation, but we have to change this. We have to change this and the rest. When I said that Senegal is taking charge of the trial of Abre, when South Africa is taking the lead, this is positive things. When the African Union decides to fight issues in the courts, goes to the ICJ, goes to the UN General Assembly, I see something positive. I see using the law, arguing to try to change the things. We can't be too optimistic. At the same time, we can't stop fighting. And I think that's what the African states, through the African Union, are doing. Fighting within the system to try to change things and get a seat in the UN Security Council, win the fights at the UN General Assembly, you know, I think that's the way to try to solve the issue. It's not an easy battle, but I think, you know, that's the only way to try to change the system. Now, different jurisprudence coming from national jurisdiction, there's two things to say about that, and I'll be quick. The one thing is that the ICC statute has been adopted, so states parties usually try to adapt their laws in accordance with their own statute. So what we see is an endeavor, an attempt to adapt your laws in so far as possible as close as the Rome statute. So that creates some kind of uniformity as between the national systems. Now, is it really a bad thing that there is a different interpretation of the law? You know, I don't know. First, there are international tribunals now that national courts can look up to form their own understanding of the law, and this has changed a lot. If you look in Canada, from Finta in 1994 to Mugesera in 2005, just on the law, it's a world of a difference because they looked up at the jurisprudence. So I think there is some kind of uniformity out of the system, and you see courts referring to each other. The Supreme Court of Canada referring to the English out of Lords and then to the House of Lords. So I think you see that. And I'm sorry?
With Africa as a guinea pig of jurisprudence, international jurisprudence.
What do you mean?
Africa is a guinea pig of international jurisprudence at the ICC, ICTR, Special Professeure Fannie, because it's other Africans who are being used as guinea pigs.
Yeah, but this is a different issue. I'm answering his questions. We can talk about guinea pigs later, but the question is, so I don't think it's necessarily bad, but I think the more and more cases there is, the more it's going to have cross-reference and come to some kind of uniformity. And Moussa, I'll answer to you later.
We have no time, unless it is no, because we are going to sabotage the program if we accept more. You generate too much interest.